Hi everyone, Craig from Team Bush with Remax Escarpment Realty. And in the next couple of minutes, you're going to find out how to avoid some costly legal problems when selling your home. When you're selling a home, there are many important legal issues that you should be aware of. To begin with, residential real estate is not an uncomplicated process. And when such a major investment is transferred from one party to another, every subtle detail needs to be reviewed. If not, they can turn into major problems. It is essential to be as informed as possible to properly protect yourself in the process of buying or selling a home. Now, there are three issues that'll certainly cost you if you're not properly informed. Because there are many legal issues to consider in that process, your first step is to wisely choose reputable and experienced professionals to represent your interest. When selecting your real estate agent, ensure you find someone who has extensive experience with the process. They should also refer you to a local real estate lawyer if you don't have one who can ensure your interests are well protected. The first clause that can be added to an agreement of purchase and sale that needs close review is the survey clause. Home buyers have the right to add a clause that the seller provide an up-to-date survey on the home they wish to purchase. When this home is yours, you should be aware of the implications of this clause. Your current survey will no longer be up to date if you've had a swimming pool installed, have had an addition installed, or fencing added since the date of the survey. If your survey is not up to date, the buyer may then ask you to provide an updated survey. In that case, the home seller will be required to bear the cost of that new survey. The cost for this process typically runs anywhere from $1,000 to $1,500 or more. Now, this is $1,000 to $1,500 less that you will net for the sale of your home. An experienced real estate agent should provide the buyer with any available existing survey, and then it is up to the buyer to decide if the survey is acceptable. Now, your agent should be able to advise you appropriately when dealing with this issue, but if you or your agent are unsure, you have the right to consult with your lawyer before you sign the offer. Now, don't be afraid to take this important step, as thousands of dollars could be riding on the decisions you make at this point. Now, the second clause to review is the home inspection clause. Some real estate transactions have fallen through because of the wording of the inspection clause. This clause often states that the buyer has the right to rescind their offer if they are dissatisfied with the outcome of a home inspection. In some cases, this is used unfairly against the seller when a minor repair issue gives the buyer a legal loophole to rescind the offer. Meanwhile, the seller has lost both time and money because of this technicality. First, they may have declined other offers which may now be lost forever in favor of the one which has now fallen through. Secondly, their home may be unfairly labeled as a problem house, which could cost the seller in terms of the dollar amount of subsequent offers netted. And thirdly, the seller then finds themselves back on the market, incurring the inconvenience and additional carrying costs of having to market their property for an additional period of time. This clause could be changed to read that the seller has the option to remedy any items that the home inspection flags. When used properly, this wording protects both the buyer and the seller. The buyer is assured that the home they're buying meets objective structural standards, and the seller is protected, if you will, against the whim of a buyer who changes his or her mind. Not all contracts will be written this way. Make sure that you're working with a lawyer experienced in real estate matters to ensure your interests are protected. The third clause that needs scrutiny is the swimming pool clause. If the home you're selling has a swimming pool, the buyer may include a specific legal clause that addresses the mechanicals of this costly item. Some contracts are written to provide a warranty for the pool that survives closing. The broadness of this type of wording protects buyers, but is not necessarily in the best interest of sellers, who might instead request those clause be worded to indicate that at the time of closing, the pool is to be in good working condition. The existence of a pool in any home negotiation is certainly reason enough to ensure that you seek advice from a real estate professional and obtain legal counsel so that your interests are represented properly. By being aware of these and other legal issues, and by seeking advice from an experienced real estate professional and obtaining legal counsel when needed, you can protect yourself against unnecessary cost and potential hardship. Now, you can request a free copy of this report by clicking the link below, or you can call us directly at 905-297-4885. If you or someone you know is thinking of selling their home, please share this video with them. If you like the video, don't forget to give me a thumbs up, leave a comment, make sure to hit that subscribe button. Also, click the bell icon so you receive instant notifications whenever new videos are released. So thanks for watching. Have an awesome day. Take care.